मुकेश भाई मधु भाई मुकेश भाई मधु भाई काला भाई बुरा भाई नैना बेन परेश भाई सुरेश भाई रैया भाई सुरेश भाई रैया भाई वकील से एमएम दीवान लेडी का नहीं जैसे नंबर 3 पूछो बाकी રહેશે નંબર 3 નો ભાઈ આપવાનું છે કશું
कौन कौन से ત્રણનો આરોપી નામ બોલો
3 નૈનાબેન પરેશભાઈ તમારો વકીલ સાહેબ આયા એટલે એમના પૂરતું રહેશે બાકી તમારું તમારી આવી ગઈ છે તમારી કઈ મુદત તમારી 4 નંબર ની આવી ગઈ
પૂછો કોન્ટેક્ટ નંબર કેવું કે છે બોલાવશો આજે આવશે
આજ આવવાના છે એવું કીધું છે
બેસાડો
ફોન કર્યો એટલે આવું એવું કીધું હા તો બેસજો હા એટલે આ એક જ લેવાના જી સર दिलीप सिंह किशोर जी वकील से अचल गुप्ता बेसो नईसत भाई नवीन भाई अली असगर अकील भाई કોણ સમાધાન છે પ્રયત્ન કરી 11 તારીખ. 11 તારીખ 11 તારીખ. વકીલ વીએસ ગુપ્તા. ચિરાગ વિનુભાઈ. કમલેશભાઈ વિનોદ ચંદ્ર. હવે પેલેનું પકડ વરણ કાઢી છે. પેલેનું પકડ વરણ આનંદ પોલ ટાઉન બજે હજુ આવ્યું.
9 તારીખનો જ.
11 તારીખ 11/12. वकील टीएम मिर्जा. मोहसिन गनी भाई. हनीफ अली महर अली. और वकील साहब समाधान થયું છે. બેસજો. તમારા વકીલ સાહેબને ફોન કરી દેજો, બોલાવી લો. વિજયભાઈ રમણભાઈ. सब अपने प्लान भी अपने राज्य में
ફોન નંબર આવ્યો?
દશરથભાઈ બાહુભાઈ. અલ્પેશભાઈ અજીતસિંહ. રફીક શાહ મહેબૂબ શાહ.
એપલએમ નો રિપોર્ટ આપો છું સર અને ઓનલાઈન સાહેબ 10,000 રૂપિયા ટ્રાન્સફર કરે તો 56,000 રૂપિયા પછી આપવાનું બાકી
હવે ચેક કરો.
રિપોર્ટ બીજામાં આપી દો.
બસ. નટુભાઈ ભૈલાલભાઈ. શું નામ ભાઈ? અને મનુભાઈ શિવાભાઈ ને બધા. આ જીણાભાઈ પ્રભાતભાઈ જયંતિભાઈ જીણાભાઈ કોઈ નથી આવ્યું? તમારા વકીલ સાહેબ હે ખંભાત ગયા છે એમ? તો આજે અહીંયા આગળ કેસમાં શું કરવાનું? આઈપીસી
પટેલ
ના માનો હોય તો મુદતની અરજી લખાઈ લાવો. આરીફભાઈ ગુલામ નબી. જાહિનબેન જાકીરભાઈ. વકીલ અસર કાજી. વકીલ અસર પટેલ. eso ભેગા કરવાની અરજી છે એટલે પેલા એટલે કોઈ હાજર નથી. વકીલ અસદ ગુપ્તા. કેતુલભાઈ તેજપાલભાઈ. વકીલ અમે પડિયાર. ઇન્દ્રિસ ખાન હનીફ ખાન. બડા સાહેબ સરકાર છે અમે 1005-24 ડિવિઝન દાખલ કરવાની. ડિવિઝન દાખલ કરવાનું 64 દિવસમાં થઈ જશે.
નોટિસ પડી
और सरकार से सर सरकार મેળા સાહેબ ખાતે થયેલા છે.
વીસ આપી 20
જી સર.
વોર્ડ નંબર.
જી સર. વીસ તારીખ ઓર્ડર મળી. વકીલ એમબી મકવાણા. અનવર શાહ નવાજ પઠાણ. નંબર 2 ની બજવણી નથી આવી સાહેબ. हजरत अली कासम अली, हजरत अली कासम अली, इकबाल अली हजरत अली, शब्बीर भाई मिर्जा, जाकिर मूसा भाई, 4 नंबर है ऑप्शन। मुकद्दर अली बाउद्दीन, शकील मोहम्मद शफी मोहम्मद, 6 नंबर। आरिफ अली कासम अली, असलम अली हुसैन अली, राहुल भाई मनु भाई, राहुल भाई मकवाणा, मगन भाई रावजी भाई, महेंद्र शंकर भाई, मनु भाई दुड़ा भाई, लालजी भाई रामा भाई, अरविंद भाई रावजी भाई, शकील सिकंदर, नंबर 16। तौफीक खान सिकंदर, आशिक मियां शमसू, 18 नंबर ऑप्शन। मुकद्दर अली अलवर अली, 416, 18 ऑप्शन। शकील सिकंदर अली सैयद,
મને ક્લાયન્ટો જે માહિતી આપી એ મુજબ જો આજે એક્ઝામ્પલ એક ગામમાં કોઈ નથી અને એનો વેરેબોસ એ સકલ જઈએ તો એનો
टीचर
साइड नंबर 26।
અશોકભાઈ મેલા પીછે આવે
अशोक भाई मेला भाई जादव, उलट तपास बाकी।
તુરંત તપાસ ચાલુ
उलट कहीं પછી ના આપતા હોય પછી ફોરેન ક્લાસીસ બેસાડ
બેસજો બરાબર, કેસ ચાલશે।
અશોકભાઈ બેસો થોડી બેસો
4 6 16 ને 18 એમનો 4 જણનો રિપોર્ટ આપી દેજો।
ખાલી 100 મિનિટ ટોપિક પર છું
પછી 6 નંબરનો ફોરમ કરજો એ તપાસ પૂરી કરે
ત્યાં સુધી ગામમાં કોઈ પણ નથાયું માહિતી આવી એટલે પછી કંઈક બીજા ઓફેન્સમાં એક્સેપ્શન
બેસા। नारायणलाल केसाजी,
દિનેશ નારાયણ છે નારાયણ કેસા ને દિનેશ નારાયણ છે
દિનેશ સોરી
हाँ दिनेश नारायण,
દિનેશ તો પકડ પડો
दिनेश भाई नारायण, हिम्मत नरोजी पोकरजी, वेरी गुड क्वेश्चन नंबर 1 4 5। किशोर भाई अर्जुन भाई, पिंटू भाई अर्जुन भाई,
સુરત જેલમાં અન્ય સુરત કામથી લાવે છે
અને મિથુન મોહન,
સુરત જેલમાં
મિથુન 5 ને
એને પુરવણીના વિશાળ
અને વિશાલભાઈ લાખાભાઈ હેડ કોન્સ્ટેબલ જીતેન્દ્રસિંહ જટુબા
આવેલા ફરિયાદી આવે જમા થઈ ગયું
મુદ્દામાં જમા થઈ ગયો
એટલે
બેસજો બેસો ભાઈ રાજદીપસિંહ હરદેવસિંહ રાજદીપસિંહ હરદેવસિંહ દિનેશભાઈ જયંતભાઈ પરશુરામ વીરેન્દ્ર અશોકભાઈ અજીતસિંહ નરેન્દ્રસિંહ 5 નંબર ઓપ્શન અજયભાઈ ગણેશભાઈ જીતુભાઈ ઉર્ફે લાલુ રોહિતભાઈ પ્રતાપભાઈ વિશાલભાઈ અને જેઠાનંદ અશોકભાઈ 9 નંબર 5 નંબર ઓપ્શન 9 નંબર ઓપ્શન 4 ગુજરી ગયા
ફરિયાદીના સાઈડ છે
સાહેબ નંબર 1 અને 15
નબી જાનમિયા રાજેશ કુમાર
રાજેશ કુમાર મેં તમારા વકીલ સાહેબને બોલાવી લેજો તમે કોણ હતા કોઈ ના રોકે 4 અને
4 નંબર પર કે એમડીમાં કોણ આવે એમની વાત થઈ ગઈ એમની વાત કેસ પટવાને તો ભાઈ પી ગયેલો
કઈ રીતે તમારા વકીલ સાહેબ ને બધા હાજર કેસ ચાલશે સાહેબ હાજર છે 1 અને 15 હસનભાઈ અયુબભાઈ
સ્પેશિયલ
સિદ્દીકભાઈ લાલાભાઈ કાનાભાઈ રેવાભાઈ અને વિપુલભાઈ બિજલભાઈ હસનભાઈ ઉભે અલ્લાહ રાખા કોણ સિદ્દીકભાઈ લાલાભાઈ કાનાભાઈ રેવાભાઈ વિપુલભાઈ વિજલભાઈ. બચી ગયું છે. એક 2 નું બચી ગયું સાહેબ, એક 2 હાજર છે, 4 4 નું બચી ગયું છે, 3 4 ગેરહાજર. 3 4 નું બચી ગયું છે. ના કેટલી કેટલી પાડી. જી સર. હા 17 12 મંગળવાર ચાલે. મગનભાઈ કાભાઈભાઈ.
કંપની ઉલટ તપાસ માટે
વન સાઈડ નંબર 2
રામદેવસિંહ નાથ.
રામદેવસિંહ નારસિંહ. વકીલ સાહેબને કહી દેજો શાહિદ હાજર છે. બરાબર? બેસજો. જસ્ટિન મોહનલાલ. મોહનલાલ ઇગ્નાસભાઈ. પૌરોમી જસ્ટિનભાઈ. નથી આવી શકતો બજવણી નથી આવી.
જીપીઆઈડી 2211 છે. દિવસના
22 11.
સચિન ડિસ્ચાર્જ.
એ તો 19 છે.
આપણા 20 તમે કરાય કઈ
20 એક બપોરે એ બાર ગામમાં પેટા ચાલે. પેટા ડિસ્ટ્રિક્ટ કોર્ટમાં 3 બાર ચાલે. 3 બાર છે. 3 બાર. હા જી સર
20 ફોર્મલ લખી દો.
બીજે સાક્ષી બહાર બેસો એ પેલા ભાઈ સાક્ષી છે ને તમે જોડે સાક્ષી છો તમે બી બહાર બેસો પછી બોલાવો
પછી બોલાવો
પછી પેલા ભાઈ શું હતો તમે આ લોકો
ના નથી એવું જ્યારે મને કે કરી નહીં ના નથી અરે સાહેબ બહાર જવું છે મને સાઇટેશન એમણે રજૂ કર્યા હું જોઈ લઉં પછી સાહેબ ગુરુવારે કઈ મારે કઈ જવાબ આપવાનો છે તો સાઇટેશન વિશે on those citation in three small aspects which would like to draw the attention of the report. Sir, my statement under 313. In my statement under 313, the main defense which I have taken, which I have pleaded again and again almost for every question, કે આંકડાઓની જે કોઈ ગણતરી છે ખોટી છે. But the most important part, which goes to the root of this case, why, Your Honor, how the matter before the Honorable High Court came to be concluded, and ultimately how the Honorable Supreme Court was misleaded on few facts, would be clarified even by my statement. Kindly see, Your Honor, my last version, which the Honorable Court's question, કે વિશેષમાં શું કહેવું છે એના અંતર્ગત I have stated, apart from the other lines, અમારી વિરુદ્ધ કિન્નાભાઈ ખોટી કાર્યવાહી ફરિયાદમાં જણાવેલ આક્ષેપો તદ્દન ખોટા અને ફરિયાદમાં જણાવેલ મિલકતોની વિગતો ખોટી હોવાનું પુરવાર થયેલ છે. ફરિયાદ અને ચાર્જશીટમાં જણાવેલ મિલકતોમાં વિરોધાભાસ છે, which is, Your Honor, apparently their amountમાં જ ફરક આવે છે. આવક અને ખર્ચના આંકડાઓ સંદર્ભે ચાર્ટર્ડ એકાઉન્ટન્ટ કે અન્ય કોઈ નિષ્ણાત મારફતે કોઈ તપાસ થયેલી નથી. અમારા દ્વારા, now this is, Your Honor, where the mess has taken place in this case. અમારા દ્વારા મોકલવામાં આવેલ ફાઇનલ નિવેદન ધ્યાને લીધેલ નથી અને અમારા આ 107 થી રજૂ થયેલ નિવેદનના પાન નંબર 4 નષ્ટ કરવામાં આવેલ હોવાનું પ્રસ્થાપિત થયેલ છે અને then, Your Honor, the further denies. Your Honor, this statement which was sent in August 2014, 19th August 2014, to establish this statement, okay, this was through the proper channel. Amreli DSP office is a वस्तु forward थયેલી, hence that TW1 was examined by us, whereby it is now apparent that yes, this was the document which travelled. Now, Your Honor, what has happened, because, Your Honor, this is a matter where matter has gone up to Honorable Supreme Court and then the trial has now, with the Honorable Supreme Court's direction, this has come up. These two orders, because it is pertaining to this very matter, the very accused who went before the Honorable High Court first, challenging the order of rejection of discharge. Your Honor, that judgment is also reported. And the recent judgment of the Honorable Supreme Court of the very accused, whereby, Your Honor, he was asked to face the trial. Even that is the reported. Your Honor, I have produced for the, because though it is there on the record, both the orders are there. For the kind perusal of this Honorable Court, sir, मैं बंने order अलग थी रजू करिया है. Kindly see, Your Honor, 2018 Gujarat High Court's judgment. Now, in this judgment, Your Honor, every aspect, importantly, Your Honor, would be on page number 2, the very first line. The investigator has considered it as rupees 1,15,35,319 and thus considered disproportionate income of 3268 to 58. However, it was disclosed that disproportionate income is rupees 51,344 and it is further contended that charge sheet paper do not reveal any circumstance or documentary evidence to reach to the conclusion that this proportionate asset is 32 lakh 68,000. It is further contended. Now, Your Honor, these are the contentions which we raise in our petition. Now, kindly see, Your Honor, para number 7. જે સાહેબ exhibit 107 વાળો આખો મુદ્દો છે. That is, Your Honor, where in para number 6 and 7, Your Honor, these aspects are coming up. The respondent have objected such application on the ground that petitioner had not disclosed all the information when matter was investigated, and at this stage no further evidence can be accepted, and that when as many as 7 statements of petitioner was recorded between 7/1/13 to 25/6/14, he has not disclosed the factual details regarding the loan, if any, received from family members and friends, and therefore now the fact cannot be considered. As against that, the petitioner is relying upon the written statement dated 19/8/2014, that is just after a couple of months from the last statement of the statement recorded by the investigating officer. However, the fact remains that though first information report is dated so and so, charge sheet is filed only on so and so, and thus after 10 months from the last date of the statement of the petitioner, therefore it cannot be said that such written statement was afterthought and thus after filing of the charge sheet only, and therefore it cannot be. This statement, which is of 19 August 14, this is prior in point of time, even when the file was sent to sanctioning officer. Mr. Brijesh Jha, who has granted the sanction, even the ocular evidence is established that this statement that exhibit 107 was not sent to him. That is not forming the part of charge sheet. And surprisingly, Your Honor, the IO has admitted that this statement was shown to him from the record of the case paper, which is originally was possessed. And from that, the annexures are missing as well as page number 4 is missing. And Your Honor, hence, it is not that something was submitted additional, nothing coming up from the pocket of the accused after filing of the charge. And this, Your Honor, aspect, when in depth it was dealt with by the Honorable High Court in para 9(2) on page number 4, Your Honor, will be kindly see. Every small aspect, Your Honor, including my purchasing of the plot, para 9(2), petitioner has also annexed relevant documents, though he has disclosed all his transactions before the department at the relevant time, when in fact department has granted prior sanction for purchasing some properties, and therefore it can be said that there cannot be an allegation that such sanction cannot be considered as a seal against corrupt practice. It is also evident from record that while purchasing a residence plot in sector 1 of Gandhinagar, petitioner sold his residential plot in sector 3 of Gandhinagar, and sanction was granted with such clarity that petitioner is permitted to sell his plot in sector 3 so as to purchase plot in sector 1. Therefore, by all means, it cannot be said that such immovable properties are purchased from the amount acquired or received by the petitioner as a bribe, and therefore it is a disproportionate asset only. Though it may not be material to decide the legal issue, the reason for the dispute as disclosed by the petitioner needs to be recorded herein, wherein it is stated that in fact petitioner has purchased the plot which was initially allotted to the member of the Legislative Assembly by the government, and thereby now he becomes owner of the house in a sector where politicians are residing. They do not want him to be a neighbor, and therefore they want him to get rid of this house at any cost. It is also disclosed that lock period for disposing the plot of the MLA by has been over, and therefore it is free from any condition, and therefore petitioner is entitled to purchase such plot from member of Legislative Assembly who has now no reason to stay in Gandhinagar, and therefore he wants to dispose the same. And now they are leaving a couple of paragraphs. Para 11 on page number 5, the last paragraph. Thereby, if the investigating officer has recorded the statement of the persons from whose account promissory note has been received by the petitioner, then there would be no evidence to consider that the amount available with the petitioner within the check period is disproportionate to his source of income, and therefore revision needs to be allowed. In fact, Your Honor, the Honorable High Court, while concluding, has ultimately relied upon the investigation papers. Now, what has happened, Your Honor, before the Honorable Supreme Court, kindly see the order of the Honorable Supreme Court, Your Honor, which is dated 9th of October 23. This is also, Your Honor, a reported judgment. It was, Your Honor, before the Honorable Apex Court, the aspect which was stated as if para number, Your Honor, is the relevant paragraph. The ratio which is there on page 1, the primary consideration stage of review of this is existence of prima facie. At this stage, the probative value of the material record need not be gone into. Para 16 here. In the teeth of the above analysis of when the impending order of the High Court is period, it would not for long set aside the contention raised by the respondent accused for the reasons of firstly, the charge sheet has been filed after taking into consideration the written submission filed by the accused before the investigating authority, which includes the documentary evidence tendered by the accused. Now, this part here. Demand by third, but Your Honor, what about my statement dated 19th August 2014, which was even suppressed from the sanctioning of officer, not forming the part of charge sheet. This, Your Honor, is one part. Firstly, which is written that this is why the Honorable Apex Court, if Your Honor, it would have been clarified that what was my final statement, what was that statement, if that would have been on record by the state before the Honorable Apex Court, my fate of the petition before the Honorable Supreme Court might have been something else. The way they suppressed it from this Honorable Court at the time of filing of charge sheet, they suppressed it before the Honorable Apex Court. The way they suppressed it before the sanctioning officer. Then Your Honor, secondly, the statement of friends and acquaintances from whom loan of large amount had been borrowed by the accused, who had been relied upon by the accused to stay off the prosecution in the written submission filed by the investigating authority, and which material has failed the High Court to accept the same on its face value to be true is nothing but short of accepting the same as defense evidence and examining the truthfulness of its content even before the trial could be commenced or held. Thirdly, the High Court has proceeded to examine the pros and cons of the defense by weighing the defense evidence and probability of the conclusion that may ultimately be arrived at on the basis of the as the basis for the exercise of the revisional jurisdiction, which was impermissible. And fourthly, the purported loan said to have been obtained by the respondent accused from his mother, brother, and brother are all question of facts which requires adjudication, and this could be done only during trial, and explanation relating to borrowing of large sum raises reasonable suspicion and has been termed by the investigating agency as strong material to file charge sheet, and basis on such material, the sanctioning officer also recorded its instruction under sanction order dated 5/3/2015 to prosecute the respondent accused. Hence, raising reasonable suspicion cannot be held as construed at a primary stage of discharging. So, Your Honor, the observations which are made with utmost respect, Your Honor, I would like to submit that had been there, Your Honor, the true picture portrayed before the Honorable Apex Court, that these are the statements which are recorded, and ultimately, Your Honor, the findings. These nothing, Your Honor, we are placed on record, which is not placed before the investigating officer. But Your Honor, what has happened there, that the moment we said that this is the statement, we in our reply to the affidavit in reply before the Apex Court, we said that in 19th August, we had stated our final report, and the state is stating that no, this is not forming the part of the charge. This is what they are. This is an afterthought which they are now bringing. Nonetheless, Your Honor, this was important to at least peruse and understand that what has happened, what is the background of the trial of this case. And this is the reason, Your Honor, I had drawn the attention of this honorable court regarding these two aspects. Now, there is one thing which the honorable, so far as the calculation part is concerned, that, Your Honor, ultimately is not disputed before the honorable apex court. Ultimately, the apex court said that whatever documents have come up from the accused side, maybe during the course of investigation also, they are required to be tried and evidence is required to be laid. Now, Your Honor, with the evidence on record, few important parts, and wherein, Your Honor, the utmost important aspect which goes to the root of this case is whether the sanction can be said to be a valid sanction. For two reasons here. Firstly, how, Your Honor, suppression of statement dated 19th August 2014 can be justified by the I. The state, Your Honor, under all circumstances, cannot justify this, that when they had something in August 2014, prior to sending the file to the sanctioning officer in December 2014, why did they conceal this? There is absolutely nothing. No answer. So firstly, when, Your Honor, there is suppression of documents from the sanctioning officer itself, that, Your Honor, would be amounting to a defective sanction. I further respectfully state, Your Honor. Second, on the second, Your Honor, the bare perusal of that sanction at Exhibit 94, Your Honor, it is the settled principle of law that it has to be by cogent reasons to satisfy as to how you are arriving at a particular decision of granting of sanction. But, Your Honor, as I had already portrayed while my previous submission, Your Honor, that on page number 1 and 2 of the sanction, it is merely what is the case against me. And on page number 2, Your Honor, in just one line, કે ઉપરોક્ત તમામ બાબતોને ફરિયાદીની ફરિયાદ અને તપાસના દરમિયાન હોય અને રજૂ થયેલા દસ્તાવેજી પુરાવાને કાળજીપૂર્વક ચોકસાઈ કર્યા પછી એવું જણાય છે કે ડીકે રાવ નાઓએ સદર ગુનો કર્યો છે and hence sanction is granted. Your Honor, what is the income? Why there is difference in complaint and charge sheet investigation? How this particular amount has been arrived at? મારી ઇન્વેન્ટરી ના લખેલી રકમો, મારા કઈ મિલકતો સાહેબ એમને ધ્યાનમાં લીધી છે, કઈ નથી લીધી, and more importantly, Your Honor, Exhibit 1 માં એટલે ચાર્જશીટ ના કાઉન્ટરમાં, Your Honor, this was very important that I would have gone or started my argument from this very line. The charge sheet માં there is one admission by the police officers who were investigated. The Exhibit 29 જે છે, જે આખા amount નું calculation, income, expenses, assets and liabilities. PW1 has also stated કે આ મેં નથી, અને he is not aware કે આ બધું કોણે બનાવ્યું છે. Now this is one part, and we see that what the first officer is doing is one thing, but what the last officer has done, who has submitted the charge sheet, in the column number 5, they have mentioned કે આરોપીની આવક ધરાવતું પત્રક, એટલે એમાં સાહેબ એક આવકનું બધું ટોટલ. Now very importantly, Your Honor, what has happened in અનુક્રમ નંબર 1 માં એક છે સાહેબ પગાર 11,90,300 87 ધીસ ઇઝ ફર્સ્ટ. પછી અમારી બાદ કરે છે સાહેબ, બાદ કપાત ધેટ ઇઝ 3,63,614 રૂપિયા. પછી પાછો સાહેબ ચોખ્ખો પગાર આવે છે, એ છે 8,26,773. હવે સાહેબ સરપ્રાઈઝ ઇન્ડિયાના પછી બાદ ફરી બાદ કરે છે 30% રસોડા ખર્ચ, અને ધેટ ઇઝ યોર ઓનર 2,48,032. સાહેબ બે વખત અલગ અલગ કપાત કરી, અને છેલ્લે સાહેબ સંભવિત બચત તરીકે મારી 5,78,000 જેટલી રકમ મારી એ આવક પ્રમાણે. નાઉ યોર ઓનર, આ જ કોલમમાં the dates are not specified. મારો પગાર એમને ગણ્યું તો કઈ તારીખ થી કઈ તારીખ, as I already submitted on check period is not clear, but આ મારો પગાર તમે જે ગણતરી ગણી રહ્યા છો that has to be clarified. હવે જો સાહેબ એ મારો અગર પગાર ગણે છે તો પછી જે કપાત, રસોડા ખર્ચ, આ બધાનો આધાર કર. Your Honor, surprisingly, this amount has no base. Now, even further, Your Honor, એના પછી કોલમ નંબર 2 માં મારી ખેતીની આવક સાહેબ મેં જાહેર કરી છે ત્યારે જ એમને બતાડ્યું. It is not that I have suppressed. Now kindly see, ખેતીની આવક it is stated 6,61,895. હવે એમાંથી સાહેબ બાદ કરે છે ખેતી ખર્ચ 40%. હવે આ 40% સાહેબ બાદ કર્યા which is around 2,64,757, અને એટલે સંભવિત બચત કરીને 3,97,137. Kindly appreciate on both these parts મારી ઇન્કમ ની કોલમ નંબર 1 and column number 2. This is the charge sheet which on both lines it is stating, the word is very important, sambhavit, and to interpret this word, Your Honor, it is all, will say it is probable. It is all about probability even after conclusion of the charge sheet. And this is, Your Honor, this word itself કે જો સાહેબ એમને ચાર્જશીટ કરતી વખતે પણ આંકડાઓ સંભવિત જ રાખ્યા છે. There is absolutely, Your Honor, nothing on record to conclusively say this thing that this is the exact amount. Now kindly appreciate, Your Honor. Then comes anya avak. Now this aspect of anya avak also, Your Honor, is very important. એક છે સાહેબ એમાં ક ખ ગ ઘ કરીને અલગ અલગ અમાઉન્ટ એમને લખી છે. આનું ખાલી સાહેબ સિમ્પલ ટોટલ મારીએ છે ને, સિમ્પલ ટોટલ ક માં લખ્યું છે મિત્રો તરફથી મળેલ મદદ 10,75,000, રોકાણ વ્યાજની આવક, બેંક લોન, રજા પગાર, ધંધા, અન્ય આવક ભાડાની, અને આરોપી તથા તેમના આશ્રિતોની બેંક બેલેન્સ 31/12 ના રોજ. આનું ટોટલ જે ચાર્જશીટમાં એમને બતાવ્યું છે that is 72,91,262. આ ટોટલ બી આ ક ખ ગ નું જે ખાલી એમનું ટોટલ માંગીએ છે ને એ ટોટલ સાહેબ એમના પ્રમાણે 72,91,262 થવું જોઈએ સાહેબ, એ બી નથી. અને એટલે જ સાહેબ આઈઓ એને આ ગણતરીમાં આ બાબતે પૂછેલું તો એને કબૂલ્યું કે ચાર્જશીટમાં જે આંકડા લખેલા છે એમાં ભૂલ છે. ઓક્યુલર એવિડન્સમાં this was posed to him and he has admitted. So now, Your Honor, when my income as per the charge sheet is, Your Honor, not clear, now kindly appreciate, Your Honor, the expense part. જે ખર્ચના કોલમમાં બી સાહેબ લખ્યું છે બાળકનો શિક્ષણ ખર્ચ 5,17,907. પછી જે સાહેબ લોન, ફાઇનાન્સ, પેશગી અને વ્યાજ 3,39,000 અને લોન ફાઇનાન્સ પેચકી અને ભરેલ હપ્તા 10,72,62,000. હવે સાહેબ આ જે રકમો લખી છે ને, આ રકમોનો કોઈ બેઝ તો હોવો જોઈએ. I'm not relying on every smallest part. વીજળી બિલ બી છે, ટેલિફોન ખર્ચ છે, ફર્નિચર, મરામત, આ તે એવા બીજા ઘણા બધા ખર્ચાઓ લખ્યા છે. પણ સાહેબ આ બાળક ખર્ચ કે ફાઇનાન્સ, લોન, પેશગી, વ્યાજ કયું ગણ્યું? There is absolutely the whole investigation is silent on this. And hence, Your Honor, એમને ઇવન પાછળ મિત્રો તરફથી મળેલ મદદ પરત કરેલી એની અંદર પાછળ સાહેબ ફિગર લખે છે, ઇન્કમમાં લખ્યું સાહેબ 10,75,000 અને જાવકમાં લખે છે સાહેબ 10,75,350. મેં કાઇન્ડલી એપ્રિશિએટ 350 ની સાહેબ amount is small, but you know ultimately I am facing a trial which is totally based on accounts, and it is my case કે તમે કોઈ એક્સપર્ટ નો જ્યારે તમે સપોર્ટ નથી લીધો, કોઈ નિષ્ણાત પાસેથી કોઈ અભિપ્રાય નથી લીધો, કોઈની મદદ નથી લીધી, જાતે કર્યું છે. તો આ 10,75 એમાં 350 નો વધારો, કારણ કે મેં ચેકથી પૈસા લીધા, મેં ચેકથી પૈસા આપ્યા. ઓક્યુલર એવિડન્સમાં એવું આવે છે સાહેબ કે મેં 11 લાખ રૂપિયા લીધા છે, સામે મેં 11 લાખ ચૂકવ્યા છે. તો આ 10,75 ની રકમ સાહેબ કેવી રીતે થાય છે, કયો બેઝ છે, એનો સાહેબ કોઈ આધાર કોઈ જગ્યાએ નથી. And hence, Your Honor, even again, Your Honor, a small part but important one. Sir, જંગમ મિલકતમાં વેગનાર ગાડી બતાડી, પણ હવે આ વેગનાર ગાડીની જે રકમ બતાડી છે ને, એ રકમ જે બિલ છે એમાં બી સાહેબ 915 સમથિંગ એનું બી એક વેરિએશન આવે છે. How this is coming? Absolutely no way. I am only highlighting that what are the small but important aspects which are going to the root of the case. Your Honor, to conclude on the legal aspects, Your Honor, the judgment that which I am relying upon, I have, Your Honor, compiled around 9 judgments in the present matter, Your Honor. And in all these judgments, Your Honor, they are mostly on sanction and mostly, Your Honor, they are all on, so just one judgment is of IPD, but otherwise most of them are on sanction and PCR. Your Honor, the first judgment, which is a very landmark judgment also of Honorable Supreme Court, reported in 2013, Your Honor, Manupatra SC, and document ID is 1230. This is CBI versus Ashok Kumar Agar. In this case, Your Honor, the legal propositions, so far as section 19 of providing sanction is concerned, Your Honor, that has been dealt with by the Honorable Supreme Court, wherein it is said that the prosecution must send a very important aspect, Your Honor, which is stated here. The prosecution must send the entire relevant record to the sanctioning authority, including the FIR, disclosure statements, statements of witnesses, recovery memos, draft charge sheet. હવે ડ્રાફ્ટ ચાર્જશીટ મોકલવામાં આવી હોય તો એક પણ વિટનેસ ડ્રાફ્ટ ચાર્જશીટ કોઈકે બનાવી હોય અને મોકલવામાં આવી, absolutely. Then, Your Honor, and all other relevant material, the record so sent should contain the material or documents, if any, which may tilt the balance in favor of the accused and on the basis of such which the competent authority may refuse such. એટલે સાહેબ 107. One such document which would have been favoring the accused ought to have been sent rather than suppressing it. Then it is in the authority, પછી સાહેબ authority ની જવાબદારી. The authority itself has to do complete and conscious scrutiny of the whole record so produced by the prosecution, independently applying its mind and taking into consideration all the relevant facts before grant of sanction, while discharging its duty to give or withhold the sanction. The power to grant sanction is to be exercised strictly keeping in mind the public interest and the protection available to the accused against whom the sanction is sought. The order of sanction should make it evident that the authority has been aware of all the relevant facts and materials and had applied its mind to all the relevant materials. In every individual case, the prosecution has to establish and satisfy the court by leading evidence that the entire relevant facts has been placed before the sanctioning authority and the authority has applied its mind on the same and the sanction has been granted in accordance with. Your Honor, here the case is something else. In fact, the IOA is stating and admitting the 107 was launched to the sanctioning office. And hence, Your Honor, my humble say that this judgment would have direct relevance to the facts of our case as well, Your Honor. Even, Your Honor, one very important part again from the sanction part also, which is observed in this judgment itself. It says the prosecution has to satisfy the court that at the time of sending the matter for grant of the sanction by the competent authority, adequate material for such grant was made available to the said authority. This may also be evident from the sanction order in case it is extremely comprehensive, as well the facts and circumstances of the case as may spelled out in the sanction order. However, in every individual case, the court has to find out whether there has been an application of mind on the part of sanctioning authority concerned on the material placed before it. It is so necessary for the reason that there is an obligation on the sanctioning authority to discharge its duty to give or withhold sanction only after having full knowledge of the material of the facts of the case. Grant of sanction is not a mere formality. Therefore, the provision in regard to the sanction must be observed with complete strictness, keeping in mind the public interest and the protection available to the accused against whom the sanction is sought. It is to be kept in mind that the sanction lifts the bar for prosecution. Therefore, it is not an acrimonious exercise, but a solemn and sacrosanct act which affords protection to the government servant against frivolous prosecution. Further, it is a weapon to discourage vexatious prosecution and is a safeguard for the innocent, though not a shield for a guilty. And in the last line, this becomes necessary. This becomes necessary because sanction has been granted in accordance with law. This becomes necessary in case the court is to examine the validity of the order of the sanction inter alia on the ground that the order suffers from the weed of the total non-application of. You know, this judgment has been observed time and again in several other judgments, even by the Honorable High Court, very recent. The second judgment, Your Honor, again a landmark judgment, though it is very old, but till date, Your Honor, it is not overruled. The judgment, Your Honor, is of 18th January 1979. This is again of Honorable Supreme Court, reported in 1979, Manupatra, SC 181 is the document. This is also, Your Honor, on the aspect of sanction, and it is, Your Honor, held in para number 3, which is the important paragraph. Your Honor. It says, a perusal of the resolution of the sanctioning authority clearly shows that no facts on the basis of which the prosecution was to be sanctioned against the appellant are mentioned in the sanction order, nor does this document contain any ground on which the satisfaction of the sanctioning authority was based and its mind applies. This document merely mentions that the sanction has been given on the basis of the note of the Commissioner Municipal Corporation, which appears to have been placed before the committee. It is incumbent on the part of the prosecution to prove that a valid sanction has been granted by the sanctioning authority after it was satisfied that a case for sanction has been made out constituting the offence. This should have been done in two ways, either by producing the original sanction, which itself contains the facts constituting the offence on the ground of satisfaction, and by adducing evidence alludes to show that facts placed before the sanctioning authority and satisfying arrived date. It is well settled that any case instituted without a proper sanction must fail, because this being a manifest difficult in the prosecution, the entire proceedings are rendered void ab initio. In the instance case, there is no evidence has been laid either primary or secondary to prove as to what were the content of the notes which were mentioned in exhibits 1. Your Honor, thereafter, the judgment which I am relying on, Your Honor, is of again Honorable Supreme Court. It is reported in 2007. Manupatra SC 879. The ratio, Your Honor, in this also is about the sanction only. Says that order of sanction can be passed by sanctioning authority only after considering all the materials connected against the accused. If the order of the sanction does not indicate application of mind, the same be produced before the court to show that such material had in fact been produced. Then, Your Honor, a very recent judgment of our own High Court, Honorable Lordship Justice M.R. Mengde, who has delivered, Your Honor, judgment very recently in May 24, whereby in case of the state of Gujarat versus Mangalbhai Waljibai Patel, it was reported in 2024, Manupatra DJ 913, Your Honor, is the document ID. The relevant, this is, Your Honor, a case of disproportionate asset owner. And in the case of disproportionate asset, when the state challenged the order of acquittal, the Honorable High Court had observed the respondent could not submit, it is the case of the prosecution that the respondent could not submit any plausible explanation for the said possession, and therefore the FIR came to be lodged against him for the present offence. Some amount of 9,50,000 euros was said to be a disproportionate asset. Here, Your Honor, observing all the other aspects in para number 9 and 9.1, Your Honor, which are the relevant paragraph, heard the learned advocate for the respective parties review the record. The first thing which requires consideration in the present case is the aspect of sanction accorded for the prosecuting the present respondent. It is settled legal position that for prosecuting a public servant for any offence is punishable under the provisions of Prevention of Corruption Act, the sanction under section 19 of the Act is mandatory. The sanction which is accorded for prosecuting a public servant is not merely a formality, but sanctioning authority is also required to apply its mind to the facts of the case, the material collected by the investigating agency during the course of investigation, and the allegations leveled against the public servant. Since the respondent was working as a range forest officer during the period in question, the sanction for prosecuting him for the present offence was granted by Principal Chief Conservator of Forest, White Communication dated so and so. The officer, namely so and so, who accorded the sanction, has been examined by prosecution by exhibit so and so. He is in his deposition has stated the papers collected by the investigating officer during the course of inquiry placed before him, and on the basis of the said papers, he had believed that the respondent was capable of investing the amount of so and so. As per the report of the ACP, the respondent was found to have invested a sum of rupees 9,50,000 in excess of his own known source of income. He had not collected any information as regards to the income of the wife of the respondent. While according sanction to prosecute the present respondent, he had not verified the details of income tax return, bank accounts, or the real estate. Upon considering the deposition of this witness of the opposite effect, it appears that he had not applied his mind to the material which was placed before him by the investigating agency, nor he had undertaken any independent inquiry to find out the truth about the allegation leveled against the respondent. Thus, the prosecution has miserably failed to prove that the sanctioning which was granted by for prosecuting the respondent was a valid sanction in the eyes of law. Ultimately, Your Honor, on this very ground, the order of acquittal, Your Honor, was upheld. Then, Your Honor, a very landmark judgment of Honorable Supreme Court delivered in state of Maharashtra versus Bolonji Daruwala, reported in 1987, Manupatra SC page 294, Your Honor. This was a case where the check period part, Your Honor, which is required, and the assumption also, which is required to be seen, it has to be very specific. That is what has been observed, that a specific period is required to be mentioned. Para number 11, Your Honor, of this judgment is an important 11 paragraph. And it has been stated, Your Honor, in this that the amount, the variation part of the disproportionate asset, Your Honor, what is the considerable proportion is also required to be seen as to what is the period of the sanction. In the present case, Your Honor, in this case, it was somewhere of the period of more than 10 years that was stated to be the check period. But ultimately, the Honorable Apex Court stated that erroneously the proposition which has been laid down, the assumptions as to joint deposits and the depositors in the first name, all these aspects are also required to be taken into consideration. That is what, Your Honor, has been observed in para number 11 of this judgment. Then, Your Honor, again another judgment, Krishnanand versus State of MP. This is also a landmark judgment. Even today also, Your Honor, when these observations are made in so far as this judgment is concerned, the Honorable Apex Court, Your Honor, has laid down in this judgment several aspects whereby, Your Honor, it is stated, it is of 1976, reported in Manupatra SC, page number is 134, Your Honor. And considering, Your Honor, the relevant portion, the relevant aspect is para number 33 of this judgment. It will be therefore be seen as against an aggregate surplus of income of rupees so and so, which was available to the applicant during the period of so and so. The appellant possessed the total assets of rupees so and so. The assets possessed by the appellant were thus in excess of the surplus income to him. But since the excess is comparatively small, it is less than 10% of the total income. We do not think it would be right to hold that the assets found in possession of the property of the appellant were disproportionate to his known source of it. Here, Your Honor, this ratio of 10% has come ultimately from this judgment. But, Your Honor, may kindly appreciate, in my case, it is ultimately, Your Honor, an additional surplus liability which is there in mine, not income, Your Honor. Why the statement also which we have produced and everything, Your Honor, and even calculations which are done, there is a additional liability on my head. Then, Your Honor, the judgment of Honorable Apex Court, a very recent judgment of last year, delivered in August 23 by the Honorable Supreme Court, reported in Manupatra SC, page number is 842, in case of Srinivas Reddy versus Rakesh Sharma. In this case also, Your Honor, the thumb rule so far as grant of sanction under CRPC 197 vis-a-vis section 19 of PCI, that has been, Your Honor, dealt with in this judgment, and it is stated that there can be no thumb rule that in a prosecution before the court of special judge, the previous sanction under section 19 of the PC Act would invariably be the only prerequisite. There is a material difference between the statutory requirement of section 19 of PC Act, no one on hand, and section 197 of CRPC on the other hand. In this judgment, Your Honor, it is ultimately been held that when so far as the circumstance of 197 is concerned, the Honorable Apex Court has laid down in para number 59 and 60, Your Honor, of this judgment, that on going to the provisions, the object behind enactment of section 19 is to protect the public servant from frivolous prosecution. Take a case where the sanctioning authority at the time of declining to accord sanction under section 19 of the PCA observed that the sanction is being declined because the prosecution against the accused could be termed as frivolous and vexatious. Then, in such circumstance, what would be the effect on the trial so far as the IPC offense law? This is the only judgment where, Your Honor, the IPC part is also been dealt with while comparing the other aspects. By the clients is from the Honorable Gujarat High Court, but Your Honor, this is of Honorable Supreme Court, where the Honorable Supreme Court had observed what would be the scenario where there are suppression of documents by the investigating officer, and what should be the outcome of it. Because this is the case where, Your Honor, Exhibit 107 has not only been suppressed, but, Your Honor, page number 4 and the annexures, Your Honor, has been destroyed. And hence, Your Honor, in this judgment, which is reported in 2014, Manupatra SC, page number 4, in case, Your Honor, of State of Gujarat versus Kishanbhai and others, para number 20, Your Honor, and 21 are the important paragraphs. Every acquittal should be understood as a failure of the justice delivery system in serving the cause of justice. Likewise, every acquittal should ordinarily lead to the inference that an innocent person was wrongly prosecuted. Para 21, Your Honor, says, on culmination of the criminal case and acquittal, the concerned investigating or the prosecuting officials responsible for such acquittal must necessarily be identified. A finding need to be recorded in such case where the lapse was innocent or blameworthy. Each erring officer must suffer a consequence of his lapse by appropriate departmental action whenever called for. Taking into consideration seriousness of the matter, the concerned officials may be drawn to the investigative responsibility permanently or temporarily, depending purely on his culpability. You know, this was the case which was actually dealt with, where documents were suppressed, and ultimately the matter was resulted into an acquittal. And last judgment, Your Honor, which I am placing my reliance, Your Honor, is from Bombay High Court. But, Your Honor, very recent one of 24th October 20, just before a couple of days, Your Honor, can say this judgment which pertain to PC Act only, dealing with section 313 and 13(1) was whereby the Honorable Bombay High Court, in para number 25, observing all the other aspects that's dealt with, it does in view of section 19 of the Act, ground for validity of the sanction on incompetency is not available to appellant. However, it is said that the application of the mind on the part of the sanctioning authority is imperative, and the orders granting sanction must demonstrate that he or she has applied his or her mind while according sanction. Admittedly, grant of sanction is a serious exercise of the power by the competent authority, and it has to be apprised of all the relevant material, and on such material, the authority has to take a concise decision as to whether the facts would show the commission of the offence under the relevant provisions. No doubt, elaborate discussion is not required. However, the decision making on the relevant material should be reflected in. My humble submission, Your Honor, based on the view taken by the Honorable Apex, very recently, Honorable Bombay High Court, as well as our own High Court, has taken an identical view pertaining to the grant of sanction. And, Your Honor, the bare perusal of Exhibit 94, it doesn't appear, Your Honor, that there is an application of mind. What documents have been considered? My respectful submission, Your Honor, that considering the overall facts of the case, the whatever charges which pertaining to disproportionate assets are being levied against the present accused, Your Honor, he may be acquitted from all. Please. Means we oblige you for to stand it. Please. Please. In case, you know, my colleague here, yeah, my colleague, local colleague, Your Honor, would take care of it. If at all there is something, I would assist you. Please. Please. Immense job. Transfer urgent होती है तो 45 नंबर इस पर पूर्ण अर्जी 845 845 But there's a very small issue involved. All there are three 138 matters, and all the three matters are pertaining to Borsad court, but all the matters, Your Honor, are before different courts. Parties are the same, complainant as well as accused is the same, transaction is the same, the written dates and everything, Your Honor, same. In fact, the sequence of the complaint 1886, 1887, 1888. Now, since all three are at different courts, by virtue of this application, I have only requested that all three be placed before any one court, not specifying as to which court, leaving it to this honorable court as to whichever court is on. Please. નોટિસ બચી ગઈ છે પછી આવે તો બી ઠીક છે સાહેબ પ્લીઝ હા બિલકુલ બિલકુલ ઇવેન્ટલી medically. All right.
Suthar.